Listen, I need you to stop what you're doing right now because what I'm about to tell you will shake everything you thought you knew about American citizenship. And if you or anyone you love has any connection to immigration in the United States, the next few minutes could be the most important information you hear all year. Right now, as I'm speaking to you, millions of families across America are waking up to a nightmare they never imagined possible. Parents are holding newborn babies in hospital rooms, being asked questions that would have seemed impossible just months ago. Immigration attorneys are drowning in emergency calls, and families who thought their path to citizenship was secure are now lying awake at night, consumed by uncertainty. This isn't speculation, this isn't some wild theory. This is happening right now, at this very moment, in hospitals, immigration offices, and homes across every state in America.
Welcome to Dream Visa Updates, where we don't sugarcoat the truth. We break down the complex immigration changes that matter, and we give you the clear, actionable information you need to protect your family's future. I'm here to walk you through one of the most dramatic shifts in American immigration history, a transformation so massive that legal scholars are comparing it to the pivotal moments that redefined what it means to be American. But before we go any further, I need you to do something that takes 2 seconds, but could save your family years of heartache. Smash that subscribe button right now. Hit the notification bell so you never miss an update that could change everything for your immigration journey. And if what we share today helps you, leave a comment below and tell us how these changes are affecting your community. Your support helps us reach thousands of families who desperately need this information. Now let's dive into what's really happening. Picture this. You're a parent living legally in the United States. Maybe you're here on a work visa. Maybe you're studying at an American university. Maybe you've built a successful business that employs American workers. You followed every single rule. You filed every form. You paid every fee. Your baby is about to be born on American soil, and you've always believed, like generations before you, that your child would automatically become an American citizen the moment they took their first breath in a U.S. hospital. That certainty, that rock-solid promise that has existed for over a century, has been shattered. What was once automatic, simple, and universally understood has suddenly become conditional, complicated, and terrifyingly uncertain. We're talking about birthright citizenship. For more than 125 years, it worked on one beautifully simple principle. If you were born on United States soil, you were an American citizen. Full stop. End of story. It didn't matter if your parents were tourists, students, workers on temporary visas, or even people without legal documentation. Where you were born determined who you were. This wasn't just policy. This was woven into the very fabric of American identity, rooted in constitutional interpretation, backed by more than a century of legal precedent. Hospitals didn't investigate parents. Families didn't worry about documentation. Children born here were Americans. Period. But everything has changed. A sweeping executive directive has fundamentally rewritten how citizenship at birth is determined. And the shockwaves are tearing through every hospital, every immigration office, every family planning center, and every community with immigrant populations across the entire country. Under this new framework, automatic citizenship is no longer guaranteed just by being born on American soil. Instead, the legal status of your parents has become the determining factor. Here's what that means. A child born in the United States now receives automatic citizenship only if at least one parent holds one of two specific statuses. They must either be a United States citizen themselves, or they must be a lawful permanent resident with a valid green card. Think about the real-world impact of this. If both parents are in the country on temporary work visas, even if they've been here legally for years, paying taxes, contributing to society, their child born in America may not automatically receive citizenship. If both parents are international students at American universities, paying American tuition, contributing to American research, their newborn may face the same terrifying uncertainty. If both parents are asylum seekers waiting for their cases to be heard, tourists visiting the country, or individuals without current legal status, their children born on U.S. soil are now caught in a bureaucratic nightmare that didn't exist before. And here's the thing. This isn't targeting any specific nationality, any particular culture, or any region of the world. This change affects everyone equally, regardless of where they come from or why they're here. The moment this directive was announced, federal agencies received orders to immediately stop issuing automatic citizenship documentation to children who don't meet the new parental requirements. Hospitals across the nation, which had followed the same straightforward procedures for generations, suddenly found themselves on the front lines of immigration enforcement. Medical staff, whose job is to bring new life into the world, are now being asked to verify immigration status, review legal documents, and navigate questions they were never trained to handle. Birth certificates that once represented pure joy and celebration now come with interrogations about green cards, naturalization certificates, and legal immigration status. State agencies managing vital records have been forced to rapidly overhaul systems that hadn't changed in living memory. What used to take minutes now requires interviews. What used to need basic information now demands extensive documentation. What used to be certain now requires verification, review, and often expensive legal consultation. The administrative burden is staggering, but the human impact is absolutely devastating. Parents who had no reason to worry before are now consumed with anxiety. They're asking questions that would have seemed insane just months ago. Will my baby be recognized as an American citizen? What documents do I need to bring to the hospital? How will this affect my child's ability to go to school, to get a passport, to access health care? And perhaps most heartbreaking of all, some parents are facing a fear that seems impossible in modern America. Could my child become stateless, belonging to no country at all? The confusion that erupted nationwide was immediate and overwhelming. Within days of the directive being announced, legal challenges started flooding courtrooms across America. Civil rights organizations mobilized. Immigration advocacy groups joined forces with constitutional law experts. Several state governments, watching chaos unfold within their borders, filed their own lawsuits, arguing that such a dramatic transformation required full legislative action from Congress, not just an executive decision. For a brief moment, it looked like the entire policy might be blocked. Multiple federal district courts issued temporary restraining orders and preliminary injunctions, halting implementation in specific areas. This created an incredibly confusing patchwork across the country. In some states, hospitals continued operating under the old system, automatically recognizing all children born on their soil as citizens. In other states, the new verification procedures went into full effect immediately. Families found themselves in complete limbo. A child born in one state might be recognized as a citizen, while their cousin, born on the exact same day in a neighboring state, faced entirely different treatment. The inconsistency was maddening. The uncertainty was crushing. Then came the moment that changed everything. The Supreme Court of the United States stepped in, not to rule on whether the policy itself was constitutional, but to address a different but equally important question about judicial authority. In a decision that sent shockwaves through the legal community, the court determined that individual district courts do not have the power to issue nationwide injunctions against federal immigration directives. This technical ruling had enormous practical consequences. Almost immediately, many of the temporary blocks that had paused implementation were lifted. The directive became enforceable in the vast majority of states, though a small handful of jurisdictions maintained temporary protections due to ongoing state-level lawsuits. What this means is that the policy now stands and is being actively enforced across most of America. Even though the broader constitutional fight is far from over, legal scholars expect this battle to continue for years. But families can't wait for legal clarity. They're living with this new reality right now, today, in hospital delivery rooms across the nation. The effects are being felt very differently depending on where families live. In states where enforcement remains paused, families feel temporary relief, always shadowed by the knowledge that the pause could end at any moment. But in states where the directive is fully active, the shift is being felt deeply and personally. Hospitals must now confirm and verify parental immigration status before they can issue citizenship paperwork for newborns. Parents are required to present green cards, naturalization certificates, passports with valid visas, or other proof of legal status. Families who don't have immediate access to these documents, whether because they're lost, in process, or never existed, face an uncertainty that would have been unimaginable just 1 year ago. Community organizations serving immigrant populations have reported an unprecedented flood of calls from worried, frightened, and confused parents. These aren't people trying to game the system. These are families genuinely trying to understand what steps they need to take, how the new rules work, and how they can plan for their children's futures. Immigration attorneys who already had overflowing caseloads are now completely overwhelmed. Nonprofit legal networks are stretched beyond capacity. Advocacy groups have begun hosting emergency workshops and legal clinics to help guide families through what has suddenly become an incredibly complicated process. The ripple effects extend far beyond the delivery room. Schools are grappling with enrollment questions for children whose citizenship status is now unclear. Healthcare providers are uncertain about program eligibility. Parents are worried about obtaining passports for family travel or even basic identification documents. The bureaucratic complications are endless. But behind every complication is a real family facing real consequences. And just when families thought they had enough to navigate, another massive shift has emerged in the American immigration landscape. This time, the changes are affecting family-based immigration, the process by which United States citizens and green card holders sponsor their immediate family members to come to America. At the heart of this process is a form known as the I-130, officially called the Petition for Alien Relative. For decades, this form has been the gateway for family reunification, allowing Americans to bring their spouses, children, parents, and siblings to join them in the United States. The I-130 petition used to focus primarily on one central question: is this a genuine family relationship? Petitioners needed to prove marriages were real, that parent-child relationships were legitimate, that sibling connections were documented. It was thorough, but the focus was clear, and the process, while never easy, was at least well understood. That process has now evolved into something far more extensive, far more demanding, and significantly more complex. Applicants are reporting that the forms themselves have grown substantially longer, with expanded questionnaires that probe into areas that weren't examined nearly as deeply before. The requests for supporting documentation have multiplied far beyond what was previously required. Financial disclosures that used to be relatively straightforward now demand detailed information about income sources, assets, debts, employment history, and sometimes even the financial situations of extended family members. Relationship evidence that used to consist of wedding photos, joint bank statements, and affidavits from friends now requires much more comprehensive documentation, spanning longer time periods and covering more aspects of the relationship. Background checks, which were always part of the process, have intensified dramatically. Investigators are looking more carefully at employment history, travel patterns, previous immigration violations, even minor ones, criminal records even for offenses that wouldn't typically disqualify someone, and any discrepancies in previous applications. The level of scrutiny has increased across the board, and processing times, which were already frustratingly long, are now expected to stretch even further. Families who were already waiting months or years may now face even longer separations from their loved ones. These enhanced requirements apply across the board. It doesn't matter if you're sponsoring your spouse of 20 years, your minor child, your elderly parent, or your sibling. Everyone faces the same increased examination. Government officials describe these changes as necessary measures to protect the integrity of the immigration system, to prevent fraud, to ensure that people entering through family sponsorship are genuinely qualified. But many families and their advocates fear that reunification, which is supposed to be one of the core principles of American immigration policy, is becoming more difficult, more expensive, and in some cases nearly impossible, especially for immigrants who lack substantial financial resources or access to quality legal representation. This shift in family-based immigration policy, much like the change in birthright citizenship, signals something larger than just administrative adjustments. It represents a fundamental philosophical transformation in how the United States views immigration itself. The changes reflect a clear move toward increased regulation at every level, toward demanding documented proof for every claim, toward careful examination of every detail of every application. Whether these changes will ultimately bring the stability and security that officials promise, or whether they will create new challenges, new backlogs, and new hardships for American families, is something that only time will reveal. As court cases wind through the federal judiciary, as new legal arguments are developed, as families adapt and advocates push back against policies they consider unjust, one thing remains absolutely clear. America is experiencing a genuine turning point, a moment that historians will look back on as pivotal in shaping immigration policy, citizenship law, and family unity for generations to come. The full effects of these policies won't be felt overnight. They won't even be fully understood in the coming months. Instead, they will unfold slowly across schools where children enroll, hospitals where babies are born, workplaces where immigrants contribute, and every corner of the vast immigration system that touches millions of lives. For families currently navigating visa applications, for those preparing sponsorship petitions, for expectant parents planning for the birth of a child, staying informed has never been more critical. Knowledge isn't just power in this environment. Knowledge is protection. Understanding the current rules, knowing what documentation you need, being aware of your rights and options. These things may be the difference between a successful immigration outcome and a devastating denial. These changes don't only affect the present moment, they are actively shaping the future trajectory of the nation, determining who becomes American, how families stay together, and what the United States will look like in the decades to come. And as new proposals continue to surface, as the political landscape continues to shift, as court decisions continue to be handed down, one thing is certain. The immigration landscape of the United States is changing rapidly, dramatically, and in ways that will have profound consequences. Understanding the rules as they exist today, right now, in this moment, may very well be the key to protecting your family's future, preserving your path to citizenship, and ensuring that you don't become another casualty of a system in flux. This is why Dream Visa Updates exists. This is why we're committed to bringing you clear, accurate, timely information about every development that could impact your immigration journey. We're not here to tell you what to think politically. We're here to help you understand what's happening legally, what it means practically, and what you can do to protect yourself and your loved ones. If this video has opened your eyes to changes you weren't aware of, if it's answered questions you've been afraid to ask, or if it's helped you understand the bigger picture of what's happening in American immigration, then please take a moment right now to like this video. Share it with anyone who might need this information, and leave a comment below telling us what immigration topics you want us to cover next. Your engagement helps us reach more families, and together, we can build a community of informed, empowered immigrants who understand their rights and options. Subscribe to Dream Visa Updates, turn on notifications, and stay informed. Because in this rapidly changing landscape, knowledge isn't just helpful, it's essential. Thank you for watching. Stay strong, stay informed, and we'll see you in the next update.